All right, everybody. It says I am recording here. I am on a Zoom conference call here with Jamie Marcario. She is our business attorney that we use whenever we have any questions for ourselves or for our clients here at Matterhorn Business Development. So Jamie, welcome back to the channel.
Oh, thank you. Oh my gosh, I feel honored to be here at a time when we really need to talk about some stuff.
Yeah, we do need to talk about some stuff. For those of you guys who have been around the channel for a little bit, Jamie was on earlier, well, I guess in 2019 to talk about Yelp and handling Yelp reviews and things like that. And that video is always one that people look at and view a lot of because there's a lot of information to cover there. So I contacted Jamie because I had a client reach out to me who has a restaurant in Ohio, and he was referencing something called the Families First Coronavirus Response Act and saying, what do I do with this? And I said, I have no idea.
Well, most attorneys don't either. And I can tell you that I am studying the novel issues for business owners and the emerging legal issues that are coming out there. The things are just changing every day, if not every hour, both at the federal level and the state level. The Families First Coronavirus Response Act is a federal law that was passed into law literally last week, and it will take effect April 1st, 2020. It's a temporary measure. It will expire on December 31st, 2020 at this juncture.
So it's going to go from April to December.
April to December. Yep.
Okay.
It is not retroactive. So whatever happens this week it doesn't affect it, right? So it's only effective April 1st. Business owners are calling me with questions about this constantly. I'm talking about this. I've been talking about it kind of nonstop since last week, since the legislation was initially proposed the week before.
Yeah.
Because it has some kind of broad sweeping effects for small businesses that are concerning to a lot of small business owners. So
what's a quick overview, or what are some of the main points so that people who aren't familiar with it, because I didn't know anything about it until I got this text. What's some of the overviews of it, and then we can dive into some of the details of it.
Okay, so at a high level, the purpose of the FFCRA, that's the rules for this, is really to extend the Family Medical Leave Act provisions, the protections that are given to employees who need to go out on medical leave for themselves or to take care of a family member who's ill. Normally, the ordinary FMLA applies to companies with 50 or more employees, and the qualifying employee has to have been employed with that company for at least 12 months. So they get paid medical leave or job protected medical leave for 12 weeks. Okay. The new expansion of that law is there are two aspects of the families. Well, actually there are more than that, but the two of concern to small business owners most are the Emergency FMLA Expansion Act component, which expands the FMLA to apply to all businesses that have 500 or fewer employees, and the qualifying employee needs to only have been employed for 30 days to qualify. And I'll go into the details of that. Sure. And then the other aspect of it that employers are concerned about is the emergency paid sick leave component of the act. So as I said, this applies to employers who have 500 or fewer employees. However, the way that you define the 500 employees, while we don't include independent contractors, they're out on this. We do include those who are already on paid leave or leave. Those who are temps, who are employed by both your firm or your company through a staffing agency or a PEO, and day laborers. So, and that includes part-time and full-time. So it's a calculating the number to get to 500 in and of itself is a little tricky. So
there's some gray areas on that.
Yeah, gray areas.
And will this FFCRA affect companies greater than 500 employees, or are they in a totally different situation?
They're in a different situation. The standard FMLA applies to them. Now there is, legislation that's being batted around right now between the House and the Senate, between the Democrats and the Republicans, all kinds of things are on the table, but we don't know that right now. Right now, everyone's concerned about the law that just passed last week.
And this is for anybody under 500 employees. Under 500
employees with employees that have been with them 30 days or more. So minimum of 30 days to qualify. So not a long period of time.
Not a very long period of time at all.
So under the Act, qualifying employees with a qualifying need, and qualifying need is defined as the employee is unable to work either at work or remotely. So this applies to people who are already working remotely because of their need to care for a minor child whose school has closed due to a COVID-19 order.
Which I imagine is pretty much every school by now, right?
Yeah, that's every school. Or the unavailability of care for that child due to a public health emergency. So it all has to be due to public health emergency.
So even if you have people already working from home and you figured a workaround, now starting April 1st, if I'm an employee and I have a kid home, I can say, sorry, I can't work. Because my child's school is closed, which is every school at this point. And then they would qualify for basically 12 weeks of coverage.
So it's called job protected FMLA. Okay. So job protected means that for 12 weeks, the employee can take off. The first 10 days of that does not need to be paid by the employer. The employee can, for that first 10 days, get paid by applying whatever paid time off or vacation time they've accrued or sick time.
So we could take that 10 days and say, okay, well, you already have some sick time approved or something else.
But that's up to the employee. So the employer cannot make them take that time. It's up to the employee to decide whether or not they're going to apply their accrued time off to that first 10 days. After the first 10 days, so for the remainder of the 12-week period, the employer is required to compensate the employee at 2/3 their regular rate of compensation, whether that's salaried or hourly. And if it's hourly, that 2/3 needs to account for the number of hours that employee would normally be scheduled to work. So that's another gray area where, what does that mean? It does not include overtime at this juncture. But what does it mean? So there's a little gray area. There will be regulations that are issued subsequently. Now that this is law, regulations will come out to tell us, here are the details that need to be followed. But right now it's a question mark. The rate does have a cap. There is a cap on what employers are required to pay. It's $200 a day or $10,000 in the aggregate over the 12-week period.
So the person won't be able to make more than $10,000 during that 12-week period. Yes, that's correct. Another important thing to know, however, is that this 12 weeks of extended job protected leave is not in replace of an employer's standard paid time off, vacation, or sick leave policy. So, for example, if you offer your non-exempt employees 80 hours of paid time off a year, this is in addition to that. They're still going to get the 80 hours after things go back to normal for the rest of the year.
That's right.
Got it.
That's right. So, and the other thing to know that's important is that if an employer fails to comply with this new law, they will be subjected or could be subjected to liability under the Fair Labor Standards Act for violation of minimum wage laws. So
if a company fails to follow these guidelines as laid out in the FFCRA, then an employee can file charges against them. Basically,
that's correct.
At this
point. They could file a lawsuit in essence under the FLSA. And if an employer, let's say, an employee comes to them and says, I intend, or I'm asking to explore this and to take this leave under the Families First Coronavirus Response Act. I want to take this extended FMLA mini leave, if you will. and the employer terminates them, doesn't need them anymore, there's a reduction in force, there's a potential for that employee who was denied the opportunity to take that leave to file a lawsuit for retaliation against the employer. So
now I guess the loophole to all this is the fact that this starts April the 1st.
Right.
Which is an interesting thing.
It's a potential loophole, and one of the loophole or not, I don't know that it's a loophole.
I guess not loophole, but
yeah,
it throws. It's a fly in the ointment that people could just lay everybody off now.
Well, and then here's the issue: is that we're in an environment where the only thing that's certain right now is uncertainty. So we don't know how long this season of health crisis is going to last. We do know it's not going to last forever, right? Correct. There will be a time when this will end. Businesses are pressing pause right now. The world is kind of holding its breath. We all need to take a deep breath and kind of focus.
Exactly.
Take the time that we need to kind of prepare for the other side of it. However, while we're leading up to April 1st, when this act goes into effect, businesses are, restaurants in St. Petersburg, Florida were forced to close effective immediately for all but takeout and delivery last Friday. So restaurants were laying off virtually all of their staff effective last Friday. Yeah. And it wasn't pleasant. No one wanted to do it. Restaurant employers are very upset. Today, Pinellas County issued a safer at home order, in essence saying non-essential businesses should, not have to, but should close their brick and mortar locations unless they are able to have people at work and maintain the safe distance of six feet apart.
The 6 feet, yeah.
Yeah, so which is not many businesses. Most businesses do not have the luxury of maintaining 6 feet distance. So right now, employers are considering major layoffs or furloughs. So, for example, a larger company, Honeywell, has engaged in a furlough policy where they are maintaining their entire staff and all their employees right now, but they're rotating out every week. People are taking turns working, in other words, and working half time and getting paid for half time instead of full time. So there are workarounds for this. But
they can do that because they have more than 500 employees, right?
Yeah. And well, they can afford to do it. Not all small businesses can afford to offer something like that. That's a luxury that larger businesses have that businesses like mine and yours probably don't have. So yeah, it's a sticky situation right now. What happens if you lay off staff right now who would have availed themselves of this next week? Would there be a retaliation claim there? I don't know. There's not an answer to that right now. So
there's a lot of unknowns still.
A lot of unknowns. Okay. The second part of the act that I think is relevant to employers is the emergency paid sick leave component of the act. Okay. So under that, an employee can take emergency paid sick leave if there is a government order for quarantine. Okay, so that's fair. Healthcare provider says that they need to self-quarantine, so they've been ordered by a doctor to self-quarantine. Or they have reported COVID-19 related symptoms and they're seeking a medical diagnosis. So if an employee just calls you and says, hey, I have the sniffles, but I'm not seeking a medical diagnosis, I'm not trying to get tested for COVID-19, and they never do, then they wouldn't be entitled to the emergency paid sick leave. But the wrinkle in that is that right now, anyway, the law does not require, and neither does the Department of Labor, there is no requirement for an employee who thinks they have COVID-19 and seeks treatment to provide a doctor's note to the employer. So how do you know? How do you know what's going on? Where do you make the error? If I'm going to make an error, I'm going to err on the side of giving the employee the benefit of the doubt, which is potentially putting me my business in a bad position.
And so what type of what is it that the employer has to do at that point? How much do they have to pay them for how long? What are the
Yeah, so it's the same. So they have as much time as the employee asks off, so under the guidelines. So it's up to same thing.
12 weeks.
Yeah, 12 weeks. However, here this has caps too. So it's not really the 12 weeks. It's really about compensation at this point. So while that employee is taking emergency paid sick leave, it's not 12 weeks, that's separate. It's that they have to be the employer has to pay that employee the greater of their regular rate of pay, one, the federal minimum wage under the FLSA, which right now is $7.25 an hour, the state minimum wage, which in Florida right now is $8.56 an hour. And so the greater of one of those. And if there's a local minimum wage that applies, so for example, in Pinellas County, certain government workers have a higher minimum wage than the state minimum wage. So they would be required, that employer would be required to pay that employee that minimum wage if it was the highest, right? Wow. Whatever's the highest, that's what the employer needs to pay. The caps on these are also a little odd. So the caps for the situations I just outlined above, so quarantine, healthcare provider orders you to self-isolate, or you're going to see a doctor because you think you've got COVID-19 and you're going to get tested. The caps on that are $511 a day or $5,110 in the aggregate. So it is a shorter period of time.
Okay.
The other cap that applies is in situations where you're caring for others, like the situation we talked about under FMLA, the mini FMLA leave or extended FMLA leave, caring for kids, caring for dependents, caring for others who are ill with COVID-19, that cap is $200 a day or $2,000 in the aggregate. So do you have any questions about that for me, Neil?
It seems like there's a lot of variables.
Welcome to Legislation 101.
It sounds like everybody's still trying to get their heads wrapped around it, right? Yeah. Now, is there any difference between any of these, between a business that has less than 10 or less than 50, or is it just anybody less than 500? It's the same across the board.
So it is in essence the same across the board for anyone who has fewer than 500 employees with these exemptions. So there is an exemption for employers whose employees are indeed actually healthcare providers themselves. Mm-hmm. There's that exemption. They don't qualify under either of these provisions. The other exemption is for employers with 50 or fewer employees within a 75-mile radius whose absence from work would put the business in a position of jeopardizing its own viability. So if by having that employee be out and paying them under this act, either the 12 weeks of leave or the paid emergency leave would jeopardize the health of the business, would jeopardize it from continuing. So in other words, it's going to put the business in a position where it, in essence, has to wind up, file for bankruptcy, or otherwise be completely negatively affected, then it's exempt. So the issue with that is that right now, there's no one to whom you report the exemption, and there's no way to say, do I qualify for this exemption? So because
it seems to me like
in the dark.
It seems to me like 90% or 95% or even 99% of the small businesses I know can't afford to not make money for 3 months and yet pay even the 2/3 of their pay.
That's right. So, even businesses who are fiscally responsible and and can operate this way, where they're keeping 3 to 6 months of reserves in their operating account or in a savings account somewhere that they have access to for times like this that are an emergency and call for cash flow. Even those employers are going to be put in a crunch position by this particular law.
There's a possibility of an exemption, but we don't know how to file it or where to file it or how it works.
Not yet.
Not yet.
So how we know how it says it works.
Okay.
But we don't know the practicalities of that, and we don't know how it's going to butt up against existing Department of Labor regulations,
all this other stuff.
Yeah, other existing regulations by other agencies and departments of the government. So
okay, so that still has to be figured out. So people should probably follow you on social media, go to your blog for updates and things like that. We'll have
we would love
links
that.
down below. Do you know, and this probably isn't part of the FFCRA, but do you know of any sort of programs that are going to help business owners with SBA loans or lines of credit or cash?
Yes, absolutely. There's a lot of information out there, and I'll tell you a great source for that in Pinellas County anyway is to go to stpetegreenhouse.com. Mm-hmm. They have a list of state and local resources that they've been aggregating. They have been doing a better job of keeping up with that, quite frankly, than I have on my page. So I would send you straight to the St. Pete Greenhouse for those resources because it's amazing how well they've kept up with it. We are aggregating a guide right now that we'll publish it won't be this week, it'll be early next week that we publish that guide that has all those resources there for you. Right now, the majority of the programs that are available for small businesses are indeed no or low interest loan programs, either through the SBA or other private lenders that are offering low interest rates right now. We have to remember, though, that those funds are not going to be fast. And everyone's getting in line right now. And if you don't get in line right now, if you think you're going to need a bridge loan, for example, to tide you over for a couple months, this is the time to go ahead and apply for it and just pay it back immediately if you don't need it, because once that system gets clogged, which will be very soon, with applicants, it's going to slow the time down that you're going to get approved or not approved, and whether you're going to need to come up with other sources of cash flow. So we're also advising our business clients to use this time of pause to get really creative about who your clients are, where they are, and how you can love them through service. I know that's an odd thing for an attorney to say, but how can you better serve the people that you already serve in this time? We've never seen this before. We don't know, no one knows what this looks like. So the normal channels through which we help our clients may not be there right now. So we need to figure out what our clients need now and how we can serve them in a way that truly helps people. So the way that businesses can best help themselves right now is not just getting in line for the loans. You need to do it if you got to do it. Do it.
Get in line.
Not just waiting on the government to give money, although that's going to be necessary too. But to really think about, how do I help people? If my business is focused on how I help people, that's going to be the best thing and the most empowering thing I can do in a crisis that makes me and my business feel very unempowered. So we can all take back our power as business owners by really thinking about what we can do for people.
Yeah, and it makes you innovate new ways of doing things. I mean, you and I spoke just briefly a few minutes ago before this started, and you never did Zoom meetings before. You never did any of these things before. You know, this is a brand new thing. And now you might realize when things go back normally, go, you know, instead of going to see that guy, instead of having him come here, why don't I just do a Zoom call and save everybody 20 minutes of car ride or whatever it might be. And, you know, it might actually help you out later on. You know, I mean, there are ways to do little things here and there, obviously, to help make a change. And that's what we want to do, is do whatever you can to service your customers now. And even if it's not for the same amount of money or any money right now, keep yourself busy, keep your guys busy. And when this all goes back to normal, you're going to be, you know, people are going to be calling businesses. The economy's going to pick back up again. You know, people need stuff that they can't get right now. I mean, I tried to buy some shoes before I came home today, and the shoe stores were closed, and I've been putting it off. Just like I put off getting a haircut and then the hair salon's closed, you know?
Oh, yeah, look at my hair right now.
was joking yesterday, like, where's my makeup department? You know, I got nobody here to help me.
Yeah.
So, you know, things are going to go back to normal. So do whatever you can, get in line for the SBA loans, get those things taken care of. Now, obviously, the FFCRA is an evolving, changing monster. So I'm going to put your information below and your blog below for people to be able to reach out and learn more about it. Now, there was one other thing that we wanted to talk about, and I don't want to keep you too long,
Sure.
but what is the part of the enforceability of contracts? Right now, like my brother, for instance, is in the home design industry and he works with contractors, and there's deadlines and there's dates and there's cabinets held up in Italy that you can't even get out of the country. I mean, what happens with contracts in this point that need to be known about?
Yeah, you know, I'm really glad you asked that, Neil, because that's about the second biggest question that I've had in the last couple of weeks. And businesses are either on one side of that spectrum or the other, or they're at some point you're going to be on both. So some businesses are like, I need this guy to stick to this contract. He's telling me he can't come through on it and he's going to breach it and he can't perform under it because of the coronavirus. Yeah. And on the other hand, we've got people who say, oh my gosh, I need to get out of my commercial lease because of the coronavirus. I had to close my operations down and I can't afford to pay my rent right now.
Right.
So at any point in time, any of us could be on either side of that equation. So we're getting that question a lot. The overarching question is, are contracts enforceable in a global pandemic? And the answer is yes. They are generally enforceable. There are a couple of exceptions. The first one is the doctrine of impossibility. I said doctrine, so you know I'm a lawyer. So impossibility means that a contract becomes impossible for the parties to perform. So it's no longer possible at all under any circumstance for the parties to perform their obligations that they committed to in the contract. So, you know, for example, in a case where you will take your brother-in-law, for example. So contractor, he's building a custom home, let's say, and this custom home buyer or renovator has said, I want these custom cabinets from Italy and that's it. And the contract specifies these cabinets specifically from company manufactured in Italy.
Yeah.
Italy is shut down.
Gone.
Nothing's coming out of there. So guess what? That portion of that contract is right now, because of COVID-19, impossible to perform on now.
There's nothing that can be done to get them delivered from Italy to the United States.
That's right. However, if that same contract said, we want beautiful custom cabinets that look kind of a picture, kind of like this, okay? Yeah. And we think that they're available from this company in Italy, but we're not being specific about who the manufacturer has to be. Well, impossibility doesn't apply.
No, because you can get other local custom cabinets made or something like that.
That's right. There could be reasonable substitutes for what could have been otherwise specified. If it's not completely specified and it's not impossible, there are reasonable substitutes. So there are ways. This is a case-by-case analysis. We have to look at the facts. We have to look at the provisions in the contract and determine whether impossibility applies.
But when it comes specifically to rent, your landlord, there isn't most likely something in your contract, your renter's agreement that says if a virus takes over and shuts everything down, you don't have to pay me money. That is a little bit different, isn't it?
It is, and it's not. So you're jumping ahead. I'm going to jump ahead.
Okay, guys, go ahead. Yeah.
I'm jumping where you jumped. You go high, I go high. Okay. So there is something in most contracts, especially contracts for services or goods, that is called a force majeure clause. That is a fancy way to say if there's an act of God that interferes with our ability to perform the obligations we have under this contract, the contract's no longer enforceable. Okay. So the issue there is that the acts of God that can be defined in the force majeure clause, they're not all created equally. They're written differently. Yeah. And some contracts and leases particularly don't include one. So if it's not in there, the lease is still valid.
It's valid.
If you've got a force majeure clause that specifies that an act of God includes global pandemic or contagion, then okay, your act of God's inclusive. But if you don't have a force majeure clause that's specific, it's up to the courts to decide potentially. And there have been insurance companies that have successfully argued that a force majeure clause, an act of God clause that wasn't specific as to its definition of what acts of God were included, actually were still enforceable. So again,
what you're saying is from now on, have a pandemic clause.
I think every contract lawyer in the country and the world is thinking that way right now. We are all realizing that what we thought was sort of a standard throwaway clause, that it was a catch-all that we just stuck in there for good measure, because we know what an act of God is.
Yeah, in Florida, it's a hurricane. That's really all you think about is a hurricane. My dad's from the Midwest, so we have tornadoes. He lost his home and restaurant when he was growing up to one tornado. So you would think, oh, this is an act of God. But now that you start to restructure, you go, okay, well, we can be affected by more than just a hurricane down here.
That's right.
So you might have to specify these things in future contracts that you might lay out.
And the other issue with those provisions right now is that the act of God that needs to be, it both needs to be unforeseen and unforeseeable, and it can't have been in existence at the time the contract was signed.
So it won't be a COVID-19 clause, but it'll be a future pandemic clause.
Yeah. So if you and I were to sign a contract tomorrow, and we included a force majeure clause, an act of God clause, and we included global pandemic, it couldn't mean this one. Correct. Because we're already in it.
We're already living.
We know about it, right? So we're agreeing to execute a contract in the middle of it. We're not doing it unknowingly. So
now, before I jumped, was there another thing you were going to say, or did you say it? Just so I make sure we don't.
I'll say, I'm going to add one more thing, and there's one more reason that a contract might not be enforceable in today's environment, and that would be if the purpose of the contract has been frustrated. So what does that mean? So if the reason that the parties decided to enter into a contractual relationship in the first place no longer exists, then the contract's unenforceable. There's no reason to enforce it. So for example, if I own or let's say I put on huge events I have conferences at big conference centers.
Wedding planning, all that kind of stuff.
Wedding planning, huge hotels. I have to put down major deposits in advance to lease the conference rooms. I have to make sure that my hotel, I have to put down deposits for my guests that are going to stay in the hotels, all of that. And then suddenly there's a governmental quarantine that closes the hotel and the conference center down. I can't put my event, I'm not able to host my event there. So, and also now we've got a rule that says, no gatherings with 50 or more people. And I think most recently in PP it's 10.
Yeah.
So we no longer have, that's all frustrated the purpose of the contract. We can't, in essence, execute on that. We can't perform under that contract, and it would likely be held unenforceable.
So if you're the planner and you've taken money from the people to plan and you've had to book things, do things, spend money, do stuff, now it's on hold, are you liable to have to give the money back to them? Or is it just sort of like you're out of luck because...
We don't know. So those are questions for the courts. But more than that, before you go court crazy, because I don't believe in going court crazy.
I think good communication is key right now.
Yes, absolutely. Very good. The big darn deal in these contractual issues is for, especially if you've got a long-term relationship with a client or a vendor, or you want to have one, it's the time to talk. Pick up the phone, call, have a video conference like this, and talk through, hey, we're being affected in the following ways. Can we talk about how we both can, whether it's possible for us to just void this contract altogether, or what's fair? Let's talk about what's fair. for both of us right now? What can we do to help each other? That's the right conversation to have. Whoever, this is my rule, whoever cries lawyer first loses. So I'm a lawyer and I'm telling you, don't cry lawyer first. Talk first.
Use good communication because they're going to be, especially now, whoever you're dealing with is in the same situation you're in.
They are.
And they want a solution too.
They do.
Your landlord doesn't want to evict you during a COVID-19 pandemic.
No.
And they don't want to lose you after this pandemic. So if you can work with them on how to pay back the rent later, hey, here's a little bit now, and then can we spread the rest out over the next 8 months of my contract? People are going to be open to communication and making it go right for everybody at this point in time.
That's right, Neil. I think you work at my firm. Oh my God, so crazy. That's great advice.
That's just great, good advice, solid advice to begin with. So we're on the same wavelength here. I think that's good. Yeah. Now, before we end off, is there any other final details we know? And then also, how do people get a hold, like you said that you had a blog post that you wrote about a lot of this stuff as well. We posted a blog yesterday on the contractual issues. We've been sending updates also via email to our list. If you'd like to get on our list, you can go to our webpage and send us something via the contact form saying, hey, I want to be on your newsletter. I want to be on your email list to get thrivelaw.com?
Yep. www.thrivelaw.com.
Okay,
you can also message us via our Facebook page, which is @ThriveLaw. I think we're @ThriveLaw PA.
Okay.
Which stands for Professional Association, not Pennsylvania, FYI.
There you go.
But you can find us on Facebook and talk to us there. You can also just email us at hello@thrivelaw.com or give us a call. We are working remotely. We're open for business. You can call us at 727-300-1990. And I will throw in that we are holding, we're opening on Saturdays and Sundays right now for COVID-19 related emergency calls. So we're waiving our consult fees for COVID-19 related business matters and employment matters so that employers who are up worrying at night about what's going to happen next have someone to call and bounce these ideas off of and what they're going to do, and
that's awesome.
What help's available to them. So
that's awesome. I'm glad that you're there and that you're doing that. And obviously there's a lot of questions that still exist even for you right now about the FFCRA and all that, but you've given us some guidance here. And I think the contract enforceability was also very interesting as well. Yep. So guys, I'm going to end this here. We ran longer than we thought we would. That's usually happens when you and I start talking. We're going to end it here, and we'll have all of Jamie's contact information down below with the links that she mentioned, but please reach out to her. Her and her team are awesome. When you call that phone number, you're probably going to get Alexis on the phone. Alexis is awesome, and she's going to help you out. So be sure you get in touch with them, and they will help you with any problems that you might have. So thank you again, Jamie, for this edition of Ask an Attorney. I'm going to stop the record button, and then you and I can formally say goodbye. But let's say goodbye to everybody on YouTube. So,
all right, bye YouTube.
Bye YouTube.